So what we're looking at today is something called the postal rule. This is an exception to the usual rule when it comes to acceptance. And under the postal rule, acceptance is deemed to have occurred at the time that the letter of acceptance is posted and not at the time that it is received or read by the person who made the offer. So the key thing here is it only applies to acceptance, and it only applies to acceptance by post. So it's got to be acceptance by post. It doesn't apply to offer or anything else. And it only applies to the post, not to any other means of acceptance, not email, not anything else. So the concept first came about in a case called Adams and Lindsell. And the rule from this particular case is exactly what we've just said. The postal rule provides that acceptance occurs when a letter is posted. So the moment it drops into the letterbox, it's accepted. Firehouse Insurance and Grant demonstrates how far this rule goes and tells us that the postal rule applies even if the letter is never actually received. In this case, the letter was lost in the post, but the moment that it was put in the post box, it was accepted. Have a think for a moment about the knowledge of the people offering and accepting. If you make an offer to somebody, you know that you've made that offer, and you know that they can accept it or terminate the offer in a variety of different ways. So you're expecting to hear something. And if you've told them that you want to hear back from them via the post, you know that you're waiting for a letter. And it's for that reason that the disadvantage, if you will, is on the person making the offer, because they know that the offer is out there and that know that they should wait to hear what the outcome is before, for example, selling the goods onto somebody else. So Howell Security and Hughes, 1974, this is an exception and says that the postal rule applies where it does not lead to a manifest inconvenience and absurdity. And notice in writing meant that the person making the offer actually needed to receive the acceptance. In this particular case, the offer was made and left open for 6 months, and the person decided to accept it right at the end of that 6-month period, and the actual letter of acceptance arrived after the 6 months had elapsed. The offeror, the person who made the offer, believed that the offer hadn't been accepted and therefore it had lapsed because the 6 months was up. And the person trying to accept it tried to rely on the postal rule, but they weren't able to do this because it would have been a real inconvenience and an absurdity. The court is essentially saying here, well, they should have got their act together and posted it in time. They had 6 months to do it, they should have done it quickly. Byrne and Van Tienhoven, 1880. We've looked at this case before. You don't necessarily need to know the exact ins and outs of who posted what and when. But what we need to know is that the withdrawal of the offer came after the acceptance was posted, so it was invalid. And the court confirmed that the postal rule applies even if the letter is never received, and that it only applies to acceptance and not withdrawal of an offer. So because acceptance took place before withdrawal, it was accepted and therefore the contract exists. So that's the situation with putting something in the post. And as you can imagine, for quite a long time, this was the only option that people had. You had to post something, you couldn't phone them, you couldn't email them because the technology didn't exist. But now we have all of these instantaneous methods of communication. And the situation here is far more difficult. Generally speaking, acceptance is immediate as long as whatever you've sent can be accessed and read. So there'll be no acceptance until then. So for example, you send an email to somebody knowing that their business closed at 5:30 and you send it at 8 o'clock in the evening. Acceptance probably doesn't take place until the business reopens in the morning. But it's not as clear cut as the postal rule by any account. Entors and Miles Far East, 1955, stated that the postal rule doesn't apply to telexes, so to fax machines. What you can see on the screen is a fax machine. If you're unfamiliar, you put in the top tray what it is that you want to send. You then dial the telephone number of somebody else's fax machine. The image is scanned and then sent via a telephone line. I have no idea how this actually works, but out the other end of the telephone line is the fax, which gets printed at the other person's fax machine. But the postal rule doesn't apply to this. So with fax machines, the rule is that it can only be accepted when it can be read. So the European Union Electronic Commerce Directive 2013 says that offer acceptance is said to have happened when the person to whom it is sent can access it. So this is probably the most authoritative piece of information that we have here. So when it comes to electronic methods, and we are probably talking about faxes now, emails, text messages, instant messages of any sort, acceptance and an offer is only said to have happened when the person to whom it is sent can access it.